The government of India has proposed 3 new laws, new additions and certain amendments to the Indian Penal Code or the IPC and the Indian CRPC or Criminal Procedure Code. But as I always say, the devil is in the details. Do we really care? So what are these 3 new bills? Let's get started by giving you a breakdown of the 3 proposals. The first is the Bharatiya Nagarik Suraksha Sanhita, BNSS. 533 sections now under this law instead of the existing 478 in the CRPC. 160 sections amended, 9 new sections added, 9 sections repealed. Now, what does it cover mostly? It covers various things, primary among them technology push, where new documents in proposed evidence law, electronic and digital recording is now something that will become part of the process. Email, server logs, documents on computer, phone or laptop messages, website, locational evidence, mail messages on digital devices, all of this has now been incorporated. Bharatiya Nyaya Sanhita or BNS. This is one of the most talked about proposals. 356 sections instead of the existing 511 in IPC. 175 sections amended, 8 new sections, 22 sections repealed. Under it, what the government calls is ensuring citizens' convenience. 0 FIRs now being made part of the process with provision of eFIR. Designated officer in every district and police station to give notice of arrest. So what it means essentially is, irrespective of the location of crime, an FIR can be registered anywhere. eFIR is also made possible. So police to inform victim of the progress of investigation within 90 days. In sexual violence cases, statement of victim to be recorded by woman magistrate. Third one, Bharatiya Sakshya Adhiniyam, BSA. Now under this, 170 sections instead of 167 in the Evidence Act, 23 sections amended, 1 new section added and 5 sections repealed. This is the Indian Evidence Act, where use of forensics is now mandated in a very big way. Mandatory use of forensics in all states, union territories, mandatory use of forensic experts in all offences, punishable with 7 years or more, necessary infrastructure in states and union territories to be created in 5 years. So these are the 3 bills and their key provisions. The changes that are being most talked about, number 1 is terrorism and organized crime, where terrorism defined for the first time in the Bharatiya Nyaya Sanhita, new section added with regards to organized crime. When you look at crime against women, new offense for sexual relationships on false promise of marriage, employment, fake disclosure of identity, etc. 20 years of life imprisonment for gang rape, where the victim is minor, provision for life imprisonment or death penalty incorporated. Summary trial, so petty cases expedited by summary trial mandatory for less serious cases like theft, receiving stolen property, trespass, breach of peace, and criminal intimidation, where punishment is up to 3 years. The magistrate may conduct summary trial. And the fourth one, in fact, is community service as punishment. These are the most talked about provisions. Public servant unlawfully engaging in trade, non-appearance, attempt to commit suicide, theft of less than 5,000 rupees, misconduct in public by a drunken person, and defamation. These are the kind of offences that could invite community service as punishment. So important thing here, of course, let me summarize once again. The key additions in the Bharatiya Nyaya Sanhita 2023, the new law proposed, covers deceitful promise to marry, covers terrorism, covers corruption, covers lynching, murder by 5 or more on the grounds of race, caste, community, covers organized crime and community service as punishment. Key additions in the Bharatiya Nagarik Suraksha Sanhita 2023 include trial in absentia, e-filing of FIR, and the trial on video conferencing. The Home Minister, while making this announcement, said that he assures the House these 3 laws will have an Indian spirit and ethos and will bring a big change in the criminal justice system. But now we have to understand what are the problems within. So what I have done is I've compiled a few problem areas after studying opinion pieces and articles written by various experts of law. So here are the 4 problem areas. Problem number 1, consultation. The process of consultation, unclear. Modes of participation, unclear. The government claims that all stakeholders have been consulted, their recommendations taken by the expert committee that has drafted these 3 proposals that the government has announced. But methodology adopted to process the recommendations, unclear. Recommendations not made public, not in the public domain. Extent of adherence to the recommendations are also unclear. Whether what the expert committee actually recommended as proposals was finally adopted in the laws also is something that we don't know. Problem 2, drafting. Manner of drafting exacerbate the risk of arbitrary arrest. This is a huge issue that has been underlined by a number of experts. For example, acts endangering sovereignty as an offense sounds draconian because it leaves a lot of scope for police to actually undertake arbitrary arrests, criminalizes certain actions, giving unchecked powers of arrest, 15 days of police custody spread over 60 or 90 days depending on the offense. So unbridled powers to the police. Remember, the Home Ministry controls the police force. So in a way, the Home Ministry has taken a lot of powers within itself to arrest. And this has been a consistent point made by the opposition that the law is often used against rival political leaders in order to settle scores. And this particular part is being looked at with a lot of suspicion that the police has been further empowered, and arbitrary arrest is something that has been raised as a risk in this particular provision. Problem number 3, the areas not adequately addressed, reforms in bail adjudication, overcrowded prisons, burgeoning under trials. It's a huge issue. It's been addressed to a certain extent, but not adequately addressed. Of course, the summary trials will take care of the petty crimes. Also, there is certain provision that has now been introduced that if you cover a certain period of your maximum punishment, even as an under trial, then you have to be released from prison if the trial has not taken place. So these are certain areas, but major exclusions. No provision similar to Section 377, which covers unnatural offences, mainly sexual offences. No provision similar to Section 309, attempt to suicide. The punishment prescribed is community service. So is now attempt to suicide decriminalized completely? That remains an area of concern. Thanks for watching. Do we really care?